with others in the region.
Council, sorry. You submitted a territorial jurisdiction being by defect in this case. Would you consider extended jurisdiction? Would it have applied here?
Could you rephrase the last part of your question?
Extended jurisdiction. I ask this because incitement to violence materialized in Tonga, where the publication was aired as genocide did not take place in Juba. So can the principle of extended jurisdiction apply? Would you consider that or not?
Your Honor, we first submit that the conduct, in fact, did occur in Tonga because it was published in Tonga. However, there could be a narrow application of the effects doctrine, a very narrow application that only applies to the crime of incitement, because when it comes to incitement, it is the words that are the actus reus. Therefore, their effects, the effects of those words, are felt in an extended jurisdiction. Turning to the issue of the direct nature of the incitement, the words are clear in text and purpose. In the Stryker decision from Nuremberg, the accused published statements in his anti-Semitic magazine that were found to be direct. He used words like annihilate, exterminate, and destroy. In one instance, Stryker himself wrote, "If Hitler freed the world from its Jewish tormentors, this would be the greatest deed in the history of mankind." In Nuremberg, this language was held to be direct. The very similar language of President Türk must also be held to be direct. The mens rea in this case is satisfied because President Türk had both the intent to incite others and the special intent for genocide to actually be committed. This special intent is found as a source from the Akayesu case. It's satisfied because the president plainly stated his desire. He plainly stated the destruction of Tuba would be his greatest achievement. In their written submissions, my friend the defense has relied heavily in paragraphs 32 through 40 on a heightened standard for mens rea, that genocide be the only reasonable inference from the circumstances. Now, this was the standard that was applied in the arrest warrant decision from the Bashir case. And this standard was rejected 2 weeks ago. If I'm correct, I believe it was 2 of your honors who were on that appeals decision. The comments by President Türk provide reasonable grounds to believe that he had the special intent for genocide, and my friend the defense should either concede on this issue of the mens rea, or he should make new submissions. Turning to the second issue, that the arrest was not only in accordance with international law, it was required by international law. When President Türk stepped foot on the soil of Rust, they became obliged to arrest him. As a signatory to the Rome Statute, Article 86 states that Rust shall act in accordance with the provisions of the statute and cooperate fully with the court in prosecution. Moreover, Article 89 requires state parties to comply with requests for surrender. I'd like to address the issue of President State's immunity as a head of state, as the president of EMBA. My friend the defense would have this court believe that his status as the sitting president of EMBA provides him immunity for the crime of incitement to commit genocide. This proposition cannot be accepted. First, EMBA is a signatory to the Genocide Convention. If I could direct your honor's attention to Article 4 of this convention, persons committing genocide or any other acts enumerated in Article 3, which includes incitement, shall be punished whether or not they are constitutionally responsible leaders. This must be taken as an express waiver of his immunity. President Türk had no immunity when he stepped foot in Rust. Second, President Türk is now before this court, where Article 27(1) removes his immunity. In the Bashir decision from the arrest warrant case, the court found that the current position of Omar al-Bashir as head of state, which is not a party to the statute, has no effect on the court's jurisdiction.
Thanks.
Do you think, or don't you think, there seems to be a clash between Articles 27 and Article 98 of the statute?
In Article 98, it states that the court shall make no request that would require the state to ignore immunities. However, President Turf had no immunity when he stepped foot in Roost. The Genocide Convention removed it, and if Roost had believed he had immunity, they could have, through Article 98, made a reply to the court. Further, his immunity was assessed in Roost, and he was found to have no immunity. Article 98 does not apply in this case. Turning to the issue of Miranda Phoenix and her audio recordings, the third issue, the prosecution requests that the witness be brought before this tribunal to give evidence. Moreover, we request that the tapes be surrendered because they provide the best evidence of what happened during the interview. Ms. Phoenix can provide evidence about what happened during the interview. The tapes provide information about during the interview. Ms. Phoenix can provide information about before and after the interview, and this context is important for the full adjudication of the facts. Tongan national law has found that Ms. Phoenix can be arrested and surrendered to this court. This court is not in a position to review Tongan national law, since as the preamble describes this court, it is a court of complementary jurisdiction. However, if it would assist Ms. Tonda, her testimony could be Ms. Phoenix, her testimony could be given from Tonda, and the prosecution would be very happy to agree to that. This is permitted by Article 93(1)(b), which allows testimony to be taken in a custodial state, and Rule 69(2) allows testimony by video link. This puts Ms. Phoenix before the chamber and makes her compellable. She's made some claims of privilege, but these claims are completely unfounded. Journalists under Rule 73 sub 2 are not an enumerated ground of privilege, and under Rule 73 sub 3, she's not protected as a class of confidential relationship. It's an
Yes, before you leave that topic, there's also the provision in Article 61(5), where the prosecutor may rely on documentary evidence or summary evidence and need not call the witness expected to testify at the trial. Would the prosecutor consider that? Or?
The prosecutor would consider it if it was absolutely impossible to have Ms. Phoenix transferred, because after all, the tapes do provide the best evidence. However, it's important for the adjudication of this case to know the full context of what happened before and after the interview. This information could in fact be exculpatory to Mr. Turf, and prosecution frankly can't understand the defense's opposition to her inclusion in the proceedings. With regard to
the provisions of the Rome Statute allow compelling a witness to give evidence?
Rule 65 allows compulsion once the witness is before this chamber.
But Miranda refuses. Miranda has completely declined to appear in court. She
has declined, but she does not. Her declining is not governed by privilege. The fact that she's declined is merely a personal choice, and she can still be compelled by Tongan law to be transferred here. If she would prefer not to be transferred, she can testify by video link. And if she chooses not to testify, she can be compelled, since her testimony is relevant and probative to the matter.
93(1)(e)?
Under 93(1)(e), could you, which provision is this?
Voluntary appearance.
Voluntary, oh, her voluntariness under, isn't that 91 sub 7 sub I?
93(1)(e).
Her voluntariness is required for transfer if there's an order made by this court. However, no order has been made by the court as of yet. The agreement is voluntary with the prosecution. Therefore, 93 doesn't govern. It's Tongan law that allows her transfer. However, if the court finds that 93 does govern, her testimony can be given by way of video link, which does not require any voluntariness. I'll now turn. Could I just have a moment to
Only a moment. But how much?